Case to come before us, a video oral argument this morning is Member Williams et al. Versus Kisling, Nestico, and Redick LLC et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. It's my understanding we have two appellant counsel today, and you have been advised that you need to divvy up your time between the two of you, however you see fit. If anyone is reserving time for rebuttal, if the appellant is reserving any time, if you let me know, I can kind of keep track of the clock to make sure that we are aware that that time is passing or coming to be. We have read the briefs and we are ready to proceed when you are, except for I need to advise you not to use the names of victims or minors. I don't think that's a problem in this case, but we are live streaming and recording this for the court's YouTube channel. So we like to make sure that those names are not used during oral argument. Again, we're ready to proceed when you are. Appellant's counsel, how will you be dividing your time?
Your Honor, it is Robert Kennedy. KNR and Dr. Gubero will be dividing the opening argument 5 minutes and 5 minutes, and the rebuttal 3 minutes and 2 minutes, with the 3 going to KNR.
Thank you. We're ready when you are.
Thank you, Your Honor. Your Honors, my name is Robert Kennedy, and I represent the KNR defendants, who together with Dr. Gubero are the appellants in this case. As this court knows, the trial court certified 2 class actions with respect to the KNR appellants. The first class involves the allegation that Dr. Gubero overcharged for medical services and equipment the KNR clients. If this court finds that this is a properly certified class and decides to send it back to the lower court for trial, the question still remains, the unanswered question still remains, what would such a trial look like? What set of facts common to all class members could adjudicate the claims of all class members in a single trial adjudication? Now, Your Honors, a class action is a representative trial. The case of the class representatives get presented to the trier of fact, whether it's a jury or a judge. The verdict is based upon the case of the class representative and the facts and the evidence of the class representative. It is then intended that this verdict would bind all class members. This court needs to look no further than class representative Tara Reid to find out that such an adjudication would not guarantee fairness nor provide due process. Tara Reid received trigger point injections, yet a presentation of her case, a verdict in her case, would bind class members who received no trigger point injections. Tara Reid received a 13% discount on her Dr. Gubero bills, yet a verdict in her case would bind class members who received no discount. It would bind class members who received a 98% discount. That's not fair. That is not due process. Tara Reid was insured by Medicaid lawyers, yet her verdict would bind class members who had no insurance, class members who had Anthem, class members who had Blue Cross, Blue Shield, class members that had App.No. That's not fair. That is not due process. A class action, again, is a trial by representation, and it—
Counsel, let me just stop you just for a minute. I know you only have 5 minutes, but I'm just going to be brief. But the point is, with your definition of a class action, it seems like you're almost wanting the claims to be identical, and that's not required.
No, Your Honor, it is not required. What is required is that the core issues can be established by common proof. The core issues in this case, with the claim that these are overcharges as compared to what the charge and the cost would have been to the client had they used their insurance. The core issues are, number one, what were they charged? Number two, what did they pay after discount? And now you have to compare it to the insurance coverage with respect to every single class member. You have different insurance coverage, different reimbursement rates, you have different co-pays, you have different deductibles. It requires a case-by-case determination, Your Honor, on core issues. These are not peripheral issues, but the core issues must have common evidence, not just common issues, but common evidence. On top of these liability differences in this first class, we have the court's remedy, Your Honors. The court's remedy with respect to KNR on the first class action is disgorgement. It's disgorgement of that portion of KNR's fee that would be attributable to that portion of the Gubriel charge that was an overcharge. Number one, the court then suggests a very simplistic mathematical formula to calculate this disgorgement. Number one, there is nothing in the record that supports the use of this simplistic formula. Number two, I believe every lawyer in this case would agree that this formula bears no relationship to the reality of how an insurance company values a claim. And third and finally, most important, this disgorgement remedy, a portion of the fee attributed to a portion of the charge would require individual discovery, analysis, and adjudication of every single class member's claim. The second class action, Your Honors, that was certified by the lower court relates to KNR's flat rate charge for for investigative services. The only way that that class can be certified, Your Honors, is to completely ignore the evidentiary record established in the lower court. First, the court ignores the existence of an attorney-client agreement between KNR and all class member clients, an attorney-client agreement that allows KNR to seek reimbursement for all reasonable expenses. Secondly, when the trial court found as a matter of law that it was, quote, pure speculation that any investigator performed any services, the trial court ignored 6 depositions, answers to 4 sets of interrogatories, requests for admissions, and documents produced with respect to individual files. Ignoring the record below, Your Honors, is an abuse of discretion. Thank you.
May I proceed, Your Honors?
Yes, Mr. Barman.
Thank you. Good morning. Please the court. As you know, I'm Brad Barman. I represent defendant appellant Dr. Sam Gubriel in this matter. Obviously, I agree wholeheartedly with the points made by Mr. Kennedy. But as the court knows, my client is only involved in this relative to Class A, what's been called the price gouging class. It is fundamental in a class action or in any civil lawsuit that you have to demonstrate that the plaintiff, and in this case, the named plaintiffs and the class representatives, class members, suffered an injury in fact. Under Felix versus Ganley, it was determined there was no showing of predominance under Civil Rule 23B3 because the class failed to establish that all class members had actually suffered an injury in fact. Whether as in Ganley or in Hong, there was an unconscionable provision in a contract, it doesn't matter. Assume for sake of argument there was. If that provision doesn't cause damages to the plaintiffs or the proposed class members, they have no ability to establish liability because damages is a necessary element of every cause of action asserted here. In this case, it is impossible to prove the named plaintiffs suffered an injury in fact, let alone that all the class members did. In order to do so, thousands of mini trials would be required for every plaintiff, for every proposed class member. You'd have to find out how they got to Dr. Gubriel, whether they had insurance or Medicaid, if they did, whether they wanted to use it, what was their insurance, what was the reimbursement at the time. And you would have to do this analysis for every individual to the prevailing reasonable rates at the time in the class period over a 10-year period of time. You'd also have to investigate what the insurance adjusters on the other side were thinking relative to settlement. And ultimately, as plaintiffs argue that this whole alleged scheme was designed to inflate the value of the case, you have to determine and acknowledge that some of the plaintiffs or class members actually did better as a result of the treatments received from Dr. Gubriel. The charges that they harp on are wholly irrelevant. Nobody was damaged by a charge they didn't pay. What Dr. Gubriel charged was irrelevant. Not one single named plaintiff actually paid what was charged. Not one identified class member to date actually paid what was charged. And I don't think plaintiffs will ever be able to identify a single class member that paid what was charged. which also means after you do the initial analysis to determine if someone suffered an injury in fact, then you have to do a separate individual analysis to determine if they were actually then damaged by what they paid, not what was charged, because again, no one did. And these things are absolutely fundamental. They destroy predominance because individual questions abound. They destroy superiority, which are necessary under Civil Rule B3 in order to have a class action in this case. Plaintiffs argue that we somehow forced people not to use their insurance, or somehow it was improper for Dr. Gubriel and his personal injury clinic not to accept insurance. There's no statute, regulation, anything that requires a physician or a medical provider to accept insurance. Dr. Gubriel was not credentialed in the personal injury clinic to do so. Every plaintiff and every class member signed a letter of protection specifically directing Clearwater, and again, it was Clearwater that was treating these patients, and it was Clearwater that was billing these patients, and it was Clearwater that was getting paid. Of course, Clearwater was never named. They named Dr. Gubriel personally, never did anything along the Belvedere framework to try and hold him personally responsible and pierce the corporate veil. That's a separate issue. But it was Clearwater that was billing and paying these and getting paid. Finally, in a little bit of time that I have left, I want to address the fact that named plaintiff Richard Harbor himself demonstrates the individual issues here and the individual analysis that would have to be done for everybody. Harbor himself demonstrates that he's not even sharing common questions of fact or common questions or issues of law with the other named plaintiffs. Contrary to the allegations, Harbor was referred to Dr. Gubriel by Dr. Ock, a chiropractor that's not been accused of anything in this case. He ended up having to go to Dr. Gubriel because his own personal care physician, who he went to first, a Dr. Haim, wouldn't treat him because he was a victim of an MBA involved in litigation. Mr. Harbor had medical insurance. He was adamant he didn't want to use it. He signed a letter of protection. He said it benefited him. That's what he wanted. He had trigger point injections multiple times. He had informed consent. He knew what the medication was. It helped him. He went back for more because it helped him. It destroys the allegations that have been made from top to bottom for the plaintiffs themselves.
Thank you, counsel. I'm going to, if you may proceed, but you're into that rebuttal time if you do. Okay,
I will save the rebuttal time if there are no questions. Thank you.
thank you. Counsel for the appellee? Good morning.
Good morning. Good morning, Your Honors. May it please the court. My name is Peter Patakos, and I represent the appellees in this matter, who are the certified class representatives who have bravely taken a stand here on behalf of tens of thousands of this law firm's clients who were defrauded by the schemes at issue. They are Member Williams, who is sitting next to me here this morning, as well as Monique Norris, and Richard Harbor and Thera Reed, who are unable to be present physically in my office this morning. And I should start by observing that I say that these people are brave because every single one of them had, after filing their complaints and after taking a stand as class representatives in this matter, were immediately greeted with counterclaims that the defendants filed against them in this case. Asserting all of these claims for defamation, tortious interference that were obviously intended to bully and silence them. Those counterclaims were then voluntarily dismissed the day before defendant Rob Nestico's deposition in an obvious attempt to keep me from asking questions about those counterclaims. And I don't want to harp on that. It is largely irrelevant to this court's analysis, but I would like to suggest and begin with reference to the ancient wisdom of the great Roman historian and statesman Tacitus, who once said very wisely that crime once exposed has no refuge but in audacity. And I hope it is as clear to this court as it is to us, having reviewed the briefs and reviewed the evidence in this matter, that this principle explains most of the defendant's conduct throughout the entire course of this litigation including the arguments that they have advanced on this appeal. And I would like to begin specifically by pointing out the basic audacity of Mr. Kennedy's primary contention that he began his argument with, that he also states in his reply brief, where he says, neither the trial court nor appellees have ever articulated what the trial of this purported class action would look like. Your Honors, I propose that that is an absurdly audacious thing to say by anyone who has reviewed the class action briefing that we have submitted in this case. It is very clear what a trial of this matter would look like. It would look exactly like the evidence that we set forth in our class action brief that was filed on May 15th, 2019. Walk right through the point headings. A, K&R operates a high volume settlement mill whose advertising dependent take all comers business model places the firm's interests fundamentally at odds with those of its unwitting clients. And walk through these point headings. That is the trial. The evidence that we have supporting each of these point headings is voluminous and extremely compelling and was obtained under extraordinarily difficult circumstances by witnesses, whistleblowers, a series of attorneys from this firm who knew that this firm had sued the first whistleblower, Rob Horton, in another case. The first attorney that came forward with evidence, he got sued as well. These people came forward anyway because this was so important to them to expose this massive fraud. So I just simply believe it should be emphasized that this idea that no one has articulated what a purported class action would look like is simply ridiculous. You know, it's the easiest thing in the world for any class action defendant to claim that a class action against them would be unmanageable, that it would require a case-by-case evaluation. Or Mr. Barman, of course, says the same thing, thousands of mini trials. It's formulaic, and here it's just absolutely nonsensical. You know, it's not especially surprising that the defendants in this case would file this appeal, would take their automatic interlocutory appeal for the purpose, if anything, of just delaying and avoiding ultimate accountability on these claims. But that certainly does not mean that there is any merit to these arguments. All they have done before this court is simply rehash the very same arguments that the trial court considered and rejected below in affirming that this case—
Counsel, but that's what we're here for. We're here for, they have to raise the same arguments or they couldn't raise them on appeal. So that's what we're here for. We're here to get to whether this is you know, class actions that can, a representative class that can move forward or not. So, you know, that's what I'd like to hear about, I guess.
I appreciate that, Your Honor. And the reason I point that out, and it's a very good point that you make, I certainly don't disagree. The reason I point out that they are simply rehashing the same arguments is that they have to show, and they avoid this, they have to show that the trial court abused its extremely broad discretion to certify class actions and remedy fraudulent schemes that impact a large number of people in the same way. The very purpose of Civil Rule 23 is to open up the judicial system to more people through class actions. Consistent with this spirit, as the Ohio Supreme Court said in the Ohalvo case, courts must not so narrowly apply Civil Rule 23 to substantially hinder the remedial purpose of the rule. Now, that's exactly what they're asking you to do here. They need to show that this court employed, that Judge Brogan, in his 54-page opinion, evinced such an arbitrary and unconscionable view of the evidence that it could not possibly be sustained here. So I would submit that what they're doing here is misrepresenting their view of the evidence that Judge Brogan considered and properly rejected. Certainly, it is Judge Brogan who has been tasked and assigned with the task of actually trying this case. So for them to say that this case is unmanageable, for the defendants to say that, of course they will say that. but Judge Brogan is the one who has to do it. And he doesn't believe that this is unmanageable.
Counsel, I'm sorry to interrupt you again, but I guess, we only have 15 minutes. I'd really like to hear about what is the common evidence for the core issues that's going to be presented. Because you do have class members and class representatives, some of them that didn't have the trigger point injections. You do have some that had insurance and didn't have insurance. There seems like there are some variances that maybe would impact the way this class could be handled, or if it even could be handled as a class.
Yes, Your Honor, I would strongly disagree with that. We believe that the evaluation of this evidence simply requires a basic calculation evaluating the amounts of the overcharge. All that needs to be done is to reduce the overcharge by the percentage of the so-called reductions that Dr. Gubriel made on every settlement. And this is set forth at page 10 of our reply brief on class certification below. These bullet points that show common proof that all class members were charged standard across the board rates for these trigger point injections. So, whether a client received a trigger point injection or not, whether a class member received a trigger point injection or not, that goes to the calculation of individual damages. Other class members will have been overcharged for other things. So certainly what's going to be shown is that the amount charged for these trigger point injections was exorbitant in all cases, and that these clients were defrauded into waiving their insurance coverage that not only would have only reimbursed the defendants for approximately $40 to $120 for what Gubriel ended up charging between $400 and $1,000 for. These rates were exorbitant and unconscionable, far in excess of what the class members' insurers would have otherwise paid for similar care from readily available sources. Then the common proof will also show that Gubriel and the defendant chiropractors did not accept insurance for payment from the class members and insisted on billing them directly from their K&R settlements. Judge Brogan observed that it is clear that this was calculated to allow them to escape scrutiny by insurance companies and other government officials for the care provided and the exorbitant rates charged. We examined Dr. Gubriel on his reason for his refusal to accept insurance from the class members, and his purported reasons are transparently pretextual and impeachable. Gubriel admits that he never discussed the cost or price of care with the class members and uses a standardized medical lien or letter of protection that purports to relieve him of liability for overcharging his patients. It can be inferred and found on a class-wide basis that all affected K&R clients relied on defendants' omissions regarding the financial impact of Gubriel's treatment under the letters of protection. One part of Gubriel's testimony was especially compelling, and especially compelling evidence of fraud. That is when we asked him about the private plane that he would fly around the state to K&R's chiropractors' offices to deliver these trigger point injections en masse. Imagine the need for a doctor to fly around a state, this state of Ohio, this big state, that there was no other doctor that could do this basic task of giving injections that we know in our briefing, the medical literature does not even support. Gubriel is doing this, and we discovered that he named the airplane, or his holding company that owned his share of that airplane, that he co-owned with Rob Nestico, defendant owner of this firm. It was called TPI Airways, which TPI is the common abbreviation for trigger point injections. He confirmed that it was named TPI Airways at his deposition. And when I asked him why, he said he didn't know why he named it that. And then when I asked him, does it have anything to do with the common abbreviation for trigger point injections? He said, no, it's not that. He was so caught up in his own web of lies about that practice that he didn't even know what he was supposed to be lying about at that point. To suggest that Ohio courts are somehow powerless to remedy this type of obvious fraud, where one of the
Counsel,
most, yes,
Counsel, I understand your passion for this, but it's not a matter of whether Ohio courts are able to remedy this type of fraud, as you say, but whether it should be proceeding as a class. Isn't that the main issue here? I mean, that's the only issue here, really. So
yes,
it's
Your Honor.
not, I don't want anybody listening to get the wrong impression that these things can't proceed. It's just a matter of whether they proceed as a class or not.
Your Honor, practically speaking, the amounts at issue are so small, relatively speaking. The average K&R settlement is somewhere between $2,000 and $10,000. So the overcharges happen on this. The overcharge happens on this low level where it's not worth any individual client to proceed as a class action, which gets to the whole point of the class action mechanism. None of these people would ever be able to recover if it weren't for the class action mechanism. And this conduct, this massively fraudulent, wide-scale fraudulent conduct cannot possibly be addressed without the class action mechanism here. So your question gets to the importance of certification here. All of the issues that defendants raise go to the individual calculations of damages. Court after court, including the Ohio Supreme Court, has repeatedly affirmed that those individual differences will not defeat class certification and should not defeat class certification here. I would also just like to emphasize other evidence that what we are talking about here is a widespread fraud that impacted all of these defendants in the same way. And the same goes for the investigation fee as well as Gubriel's overcharges. These were schemes that were intended to exploit a high volume model. And the nation's leading expert in these high volume settlement mill law firms has affirmed that in her affidavit that was attached as Exhibit 1, that sets forth in extremely compelling detail what was driving this fraud on both classes of claims. Mr. Kennedy takes issue, and I will focus on the investigation fee briefly. Mr. Kennedy takes issue with Judge Brogan's evaluation of the evidence, but Judge Brogan's statement as to what that evidence showed is very clear. He calls it an ambulance chasing fee. He points out that there is no evidence that the work of these so-called investigators was ever tracked, or that any of it was ever kept track of by any of the investigators or any of the law firms. Judge Brogan says the evidence supports a finding that no actual investigation was done, and that instead the fee is a sham sign-up fee. It will prevail or fail in unison because it pertains to a single underlying scheme. Common questions predominate as to this fee, through which K&R extracts payment from their clients for the ordinary overhead cost of performing a sign-up. So they can come in here and argue that each one of these investigators did something different, but they haven't presented any evidence below to show that these investigators ever did anything that would not have been already subsumed in the law firm's ordinary overhead expenses that the clients were already paying through their contingency fee.
And
Again,
counsel,
we're talking about a widespread fraud.
thank you, counsel. Need to let you know that you've utilized actually just over your allotted time, as I've given the appellants a little extra time as well to keep it equal. Thank you very much for your presentation today. Mr.
Thank you,
Kennedy,
Donna.
I believe you are going to do the first part of the rebuttal. Is that correct? And your microphone is on mute still. Thank you.
Thank you, Your Honor. I have limited time, but Your Honor's appellee's argument, unfortunately, is it's just a further example of the approach to this entire litigation. In an attempt to deflect from the requirements of Rule 23, in a limited presentation today, they again have talked about settlement mills, a Stanford professor, an ancient philosopher, me misrepresenting, being audacious, me being ridiculous, a whistleblower lawsuit, and a private airplane. This is about class certification. Not everybody in the world would agree with the business model of KNR. They aggressively advertise. They absolutely do. But this is about class certification and the requirements of Rule 23. The claim in the brief and the claim again today that this trial is all set because there is common proof. There are 3 claims of common proof that have been made by appellee. Number 1, quote, all class members were charged a standard rate. That is simply inconsistent with the record. The charges were discounted between 0% and 98%. The second claim that they said is common proof with respect to all class members. Number 2, quote, all charges were exorbitant compared to insurance rates. To prove that all charges were exorbitant compared to insurance rates requires individual determination of the insurance policies of each class member so that you know how much was going to be reimbursed, you know their copays, you know their deductibles. The claim that 100% of the class members have been damaged is frankly, it's just an untenable conclusion given the fact that some, for an office visit, had a 98% reduction of their charge. They haven't been damaged. But again, to determine whether they have, you got to look at every individual case. And third and finally is the claim in the briefing, and again today, common proof will establish that there was no legitimate reason to not use health insurance. The claim that that evidence is common across the board. Your Honors, we know that a substantial part of this class had no insurance at all. We know that the class representative, Mr. Harper, had insurance, but he refused to allow KNR or Dr. Gubriel to use it. Again, the claim that these 3 aspects of a liability determination by appellees, their claims involve proof common to all class members is simply not supported by the record in this case. I think—
Counsel, I know you have limited time, but I'm really interested with the investigative fees. That doesn't seem to be in the same boat with your arguments, because investigative fees sounds like that's a simple thing that everybody was charged. So why is that a problem to have that as a class action?
Because, Your Honor, even if this court were to determine, they try to focus into one issue. Even if this court were to determine that KNR was not allowed to charge, let's say, $50 for a sign-up fee, they still have a contract that allows them to charge for any reasonable expense. So you must look at each individual class member and make a determination as to whether or not the investigator did something that allows the charge. So if you open any client file, you will see photographs taken by the investigator. You'll see witness statements taken by an investigator. You will see emails saying, can you deliver this? Can you deliver that? So to determine whether or not there were services provided by an investigator that would substantiate, that would justify the $50 charge, you have to look at all of the files, Your Honor. You have to simply do that. They had a contract that allowed them to charge for reasonable expenses. So even if they shouldn't have charged for a simple sign-up fee, that doesn't end the inquiry, because under their contract, they are allowed to charge for any reasonable expense. Some of these clients—
Counsel, Counsel, I know you want to allow some time for your other appellant counsel, and you have utilized in addition to that 3 minutes. So
I apologize. Thank you. I very much appreciate the opportunity to be on vacation and appear before you by Zoom. Thank you.
thank you. Mr. Barman, you have about 1.5 minutes.
Okay, thank you. Briefly. First off, in typical fashion, at the beginning of his argument, Mr. Patako said the defendants, plural, filed counterclaims against these plaintiffs. So the record is clear. Dr. Gubriel did not counterclaim against anyone, although none of that is relevant to the issues here in Rule 23. He also said that we did not show that Judge Brogan abused his discretion in certifying these classes. That's false. That's exactly what Felix and Hong found, and that is the law in the state of Ohio. If you cannot demonstrate an injury in fact, it is improper to certify a class, and that's exactly what happened here. Most telling is what Mr. Patakos did not say. He didn't address what these people actually paid and the issue of injury in fact. He ignored it completely, and he kept talking about the overcharge, the overcharge, the overcharge, because he understands the charge is irrelevant. To determine whether someone was actually damaged, you have to look at what was paid, and no one paid what was charged. So again, the charges are irrelevant. Mr. Kennedy covered the issue with Mr. Harbor. He had insurance and chose not to use it. You'd have to look at every individual to see if they had insurance, what it was, how it worked, and whether they wanted to use it. And Mr. Harbor himself destroys that argument. Finally, Your Honors, I didn't raise this in my initial argument, but it's in my briefs. And since Mr. Patakos talked about it, he talked about the medical literature does not support the use of trigger point injections. We have argued from the beginning on behalf of Dr. Gubriel that this was a improperly disguised med mal case because Mr. Patakos understood a med mal case would be time barred.
And
Criticizing,
counsel,
yes.
I understand that. We did see that in the brief. I need to let you know, however, that you have utilized the time remaining for the appellant's argument today. Thank you all for your presentations.
Thank you for your time.
The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. We are adjourned until our next video oral argument, which is Thursday, July 15th. Again, thank you all for appearing by Zoom today and arguing your cases. Have a wonderful day.
You too. Thank you.